Hi, this is Mike Elliott, and you're watching the SEC Filings TV Thought Leader Series. In this episode, we'll be talking to Mr. Barry Szaferman, founder and managing partner of the top-ranked law firm of Szaferman Lakind, which provides legal representation for businesses, municipalities, investors, and other professionals. We will also be joined by Mr. Greg Jaclin, who is the latest partner to join the Szaferman Lakind team. Good afternoon, gentlemen. Thank you for joining us.
Good afternoon, Mike.
Good afternoon, Mike.
Barry, to start off, can you provide us with a brief background about Szaferman Lakind Attorneys at Law and your firm's background in corporate finance law?
Sure, Mike. The firm started in 1977. Three original partners, myself, Arnie Lakind, and Jeff Blumstein, were all together. We were a lot younger then and looked a lot different, and we did a lot of different work as young attorneys trying to build a practice. Over the years, the practice grew substantially, and we focused on a business practice and a litigation practice. In the business practice area, we ended up representing a lot of banks, a lot of developers, a lot of individuals and corporations, many of whom were interested in corporate finance and in finding the most effective way to borrow money for their various businesses. As the firm grew, we realized that we needed different tools for our more sophisticated clients, and also we needed to have a mechanism for some of the startup companies to raise money. Recently, we were fortunate to have Greg Jaclin and his securities group join the firm to enable us to provide those broad opportunities for our clients, not only to borrow from the community banks, the larger banks, but to do the more innovative financing.
Thank you, Barry. In 2012, nearly $900 billion of private capital was raised, representing about 40% of all capital raised in the U.S. Can you discuss how these transactions take place through Regulation D and the process that occurs?
Yes, Regulation D is actually broken down into three different areas. It's Regulation D, Rule 504, Rule 505, and Rule 506. 504 is a limited exemption that allows the company to solicit investors, but they can only raise up to $1 million. The advantage of the 504 is you do have solicitation, meaning you can actually advertise for to raise the money, but you're limited by the $1 million. Rule 506 is more limited in terms of the fact that you can't really solicit, but you can raise up to $5 million. So it's not used very often. Then there's Reg D 506, which is the most common use of Regulation D. Most of the $900 million is probably used on Regulation D Rule 506, which allows the company to raise an unlimited amount of money from up to 35 non-accredited investors. So the company can raise as much money as it wants, have as many investors as it wants, as long as it doesn't go over 35 non-accredited investors. Now, there were certain limitations there. The biggest one being is you could not solicit. You basically had to go to relationships. You could have a placement agent that has a relationship, but you couldn't cold call. You couldn't solicit on email or in a newspaper or anywhere else. It limited the solicitation in the old Regulation D Rule 506 rules. And that's where most of the $900 million was raised last year.
Okay. So on September 23rd, 2013, the SEC issued Rule 506C that will allow these capital raises to be advertised to the public. Could you provide us with an overview of these new regulations and a little bit of the impact you think it will have on the market?
Yeah, I think that they're going to have a big impact on the market. They're already having a big impact on the market. The biggest difference from the old rules, as discussed before, was you were limited on a 506 offering in terms of solicitation. You could not advertise via email, via newspaper. You couldn't do a mass solicitation. Under the new Regulation D Rule 506 rules, you can do a mass solicitation, whether it's on a website, a portal, emails, newspaper. You are able to mass solicit now, which makes a tremendous difference in terms of bringing investors. There are new regulations, though. Under the old rule, like I said, you could have up to 35 non-accredited or sophisticated investors. Under the new Reg D 506C rule, if you are going to use the solicitation rule, then you have to only go to accredited investors. In addition, there are new ways that you have to determine if somebody is accredited, which we'll get into in a couple minutes, but it's much more stringent in terms of the rules of determining whether somebody is solicited or not. The other thing you have to be very wary of is that there's disqualifications under the new Reg D 506 rules. There were previous disqualifications, and they're called bad boy rules. I'm going to relate to them as I call them bad boy provisions, which don't allow you to use the exemption if there's a bad boy that was involved with the company. Basically, if somebody's been arrested or has a securities issue, there's a number of things which we can go into further, which would disallow the company from having the exemption. Under the old rules, they weren't as prevalent. You didn't have to do as much research. It didn't apply to some of the past people that were involved with the company. But now they're very strict in terms of, if there's a bad boy involved with the company, then they're not going to be able to rely on the exemption.
So in raising capital under 506C, how can companies ensure that they're actually advertising to only accredited investors, or is that possible?
So again, this is one of the new requirements under Reg D 506, which is if you're going to do a solicitation, you can only bring in accredited investors. Obviously, it's not possible to make sure that you're only soliciting accredited investors if you're going to do a mass solicitation. But if you're going to raise money, any money you raise has to be from an accredited investor. The big difference from before was the way that a person confirmed whether they were accredited or not was just checked off on a subscription agreement confirming whether or not they met certain requirements that made them an accredited investor. Under the new rules, they have to provide certain bank information, whether it's a tax return, an account statement, something confirming the fact that they actually are accredited. And what they will also allow is are allowing representatives to go in and basically certify that somebody is accredited. So there could be third parties such as attorneys, accountants, certain certified professionals are allowed to go in, check somebody's bank statement, and then they can provide the representation to the company. Under the rules, though, the company cannot take money unless they get this verification either from the third party or directly from the investor that confirms that these people actually are accredited investors and not just completing the subscription agreement, which was allowed under the old rules. This is a big change. It's extremely onerous for the company, but obviously the advantage of the rule of allowing the mass solicitation certainly outweighs the use of having to get making sure that the company and the investor are accredited.
And in the future, the SEC plans to implement rules opening up private investment to non-accredited investors. Could you discuss how you see that process happening?
Well, under the current rules, there are still private investors that are non-accredited can still invest. Under Reg D 506, not using 506C, non-accredited investors can still invest in the company, but not if the company is using the general solicitation rules. So they still have that avenue. They still have 504. It's just under the new 506 rules, which limited the new 506 rules with the solicitation, which limited just to accredited investors. I am aware that the SEC is talking about opening up investments to more non-accredited investors. I'm not aware of anything specific on the horizon right now. I think that if companies want to go after non-accredited investors, then they'll have to just rely on the old 506 rule or 504 or 505, which allows for non-accredited investors. But I'm not aware of any new specific regulation that's coming around soon. And based on the fact that the SEC seems to be more strict on these things in terms of making sure that people understand what they're investing in and are accredited, I don't necessarily know that that's going to come around anytime soon.
And Greg, that's all the questions I had for today. Were there any other comments or anything else you wanted to add before we close?
Yeah, I just want to stress that I think that the new 506 rules are going to have a tremendous impact on the marketplace. I think we're seeing it already. I think over the last month or so since the rules have been implemented, investments have picked up. I know with our firm, we're working on a couple of PIPEs, private placements, for accredited investors only that we weren't working on before. So I think the overall impact is going to be positive. I know a lot of people, especially when you combine this with crowdfunding, groups are setting up portals that allow accredited investors to get together with companies. So I think that which would not have been allowed under the old rules. So I think this will be a positive for small companies, small mid-cap companies looking to raise capital in the future. I do caution companies to make sure that they have the exemption available to them. I touched quickly on the bad boy exemptions. They are extensive. There are a lot of requirements there. I highly recommend you speak to a professional, speak to an attorney. This is what we do. I'd be happy to speak to people if they want to know more about it. But they have to understand and make sure the exemption is available for them, that they're making sure that people are accredited, and they're making sure that they don't have any bad boy disqualification, which would allow them not to use the exemption. Thanks, Mike.
Greg, thanks again to you and Mr. Szaferman for taking the time to join us.
Thank you.
We've been talking to Mr. Barry Szaferman, founder and managing partner of the top-ranked law firm of Szaferman Lakind, which provides legal representation for businesses, municipalities, investors, and other professionals, as well as Mr. Greg Jaclin, who is the latest partner to join the Szaferman Lakind team. You've been watching SEC Filings TV. Thank you for joining us.